Welcome everybody to a mid-month impromptu breaking news building doctor show. I am your building doctor, Jens Johansson, J2 Building Consultants. As many of you know, we have a monthly webinar. The last Tuesday of every month, we take your live questions and give you answers, talk about particular topics that may affect you, your board, your association, and your community. Well, if you live in Washington State or have a property there, we have new breaking news. House bill that was signed at the beginning of May. Email I received from the Washington chapter of CAI, Condominium Association Institute. And it's a good group to be a part of. I'd encourage you to look it up. So this email comes from House Bill 1199 that was signed into law May 1st. It essentially prohibits an association from unreasonably restricting or limiting the use of a unit as a licensed family home child care or a licensed child daycare center. However, it does allow an association to impose various requirements on a unit operating as such. The CAI encourages you to read the bill, so do I. The association may require, you can't prohibit them from doing it, but it may require them to A, provide direct customer access to the unit in order for this to happen. So think about it. If you have a private gate with a gate code, whether it's for cars or whether it's for just people, you as the association can require that business to provide its own customer access code. So you're not giving out that security code to all the people that attend. Some people may attend one day for short-term childcare and then now have a code to your property. So something definitely to think about there. The association can require them to be licensed by the Department of Children, Youth, and Family Services. Definitely agree with that. The association may require them to indemnify all claims related to this daycare center, except for claims that arise in common elements that the association is solely responsible for maintaining. Okay, we have been beating this drum. And what does that mean? So the unit itself has a deck. It's child play care on the deck, and the deck is a little rotten, and maybe its beams look like that, or its steel columns look like that. And if that deck were to fail because it had a whole bunch of kids on during recess on the deck or whatever it is, wow, the association is responsible for that issue because it's a common element. What if it's a second story unit and to get to that front door requires them to walk on a walkway? Well, we don't have the money to fix the walkways this year, but somebody slipped and fell or went through the railing that was non-compliant. I'm giving you collapse examples. But what about that old rail from 1976 that, is 7-inch apart on those vertical stiles of the railing and is not up to current code, which is 4 inches. And now we have a bunch of kids there and they're getting their heads caught and they're getting hurt. Watch out for that. That's a big thing. And make sure you get just blanket indemnification. But this ties in the common areas that we've been really soapboxing about. The next thing, you can require that daycare to provide insurance, obtain and provide insurance. And here's an interesting one. Provide the association with signed waivers from the guardians of each child that releases the association from legal claims related to the operation of this daycare center. Now, from that previous bullet, you can't be released from something you're supposed to maintain, but it's an extra layer of insurance. So 20, 30 kids at this daycare, you will have 30 waivers from the guardians or parents of each child, naming the releasing the association. So it goes on to say you can't develop special rules. They have to apply equally to all other members of the association. The board members should consult an association attorney. Even Hazel, the building inspecting lab, says that you should do that. You can hear her whining in the background. So talk to your HOA attorney. really dive into this thing. It was signed on the 5th of May and it went into effect immediately. Here is the looking it up on the state site, effective 5/1. So make sure you're aware of this and make sure you start talking about it and taking care of your common elements that this daycare business may do. So, end of update. Don't forget, attend our live webinar last Tuesday of every month. See you soon.